Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we have an interesting case from the Seventh Circuit, which is out of Illinois, and it is an interesting case because it involves something that happens very, very rarely, and that is potential juror misconduct. Now, one of the things that always happens at a trial is before you even get started, the judge reads a long series of instructions. And he tells you that you can't talk about the case with the other jurors until all the evidence is in. That's considered to be deliberating prematurely. Many state courts allow people to take notes, and those instructions are given. And there's a whole bunch of instructions, and the jurors are told you need to follow these instructions because these instructions guarantee that the defendant in a criminal case gets a fair trial. And that's pretty important. That's part of your rights under the federal Constitution, that you have a right to a fair trial by an impartial jury of your peers. Unfortunately, in spite of everything that judges do to make this point, sometimes jurors go off the rails and they decide that they know better than the court does. If you have ever read John Grisham's book, The Runaway Jury, that was a story about a juror that essentially hijacked a jury trial and ran away with it. It's an interesting read, but I don't believe it has ever happened in the history of the United States court system. But it's worth a read just to get an idea of how this could happen and how it could be very unfair for a defendant in one of these cases. Now let's take a look at the opinion and see what the Seventh Circuit had to say in this case about this issue of potential juror misconduct. So this is the case of USA versus Luis Garcia, and it's from the Seventh Circuit. It says Luis Garcia provided logistical assistance while another man unloaded items from a secret compartment on an empty bus. The items turned out to be controlled substances, and based on his involvement in the affair, Garcia was convicted of possession with the intent to distribute controlled substances and conspiracy to do the same. So he challenged two issues on appeal. First, he said there was insufficient evidence, and second, he challenged the court's denial of his motion for a new trial based on notes that jurors submitted to the court during trial. We affirm, when viewed in the light most favorable to the government, there was evidence that Garcia knew the bus contained controlled substances, and although the multiple juror notes show something strange was happening with the jury, we cannot say the district court abused its discretion, concluding that the strangeness did not rise to the level of misconduct. The events underlying the prosecution took place in 2017. Garcia told a guy named Navarro that he needed to use his garage to take care of a truck that would be coming in, and that he'd take all night to unload the bus. Meanwhile, the guy who was actually doing the transport, Luis Espinola de Michel, was driving from Mexico to Navarro's garage on the bus. His job was to unload the drugs when he got there, and apparently it's a fairly involved process involving taking out all the seats on the bus and removing the traps where the drugs were. Later on Friday, when the bus arrived at the garage, Garcia was there to meet it, and he allowed the bus to, wasn't allowed on the bus to help see how things were done. I guess they wanted to keep their method secret, but he helped this guy Espinola by bringing him tools and food and luggage and that kind of stuff. So as he had a conversation with Navarro, Navarro testified under oath that it was about the same thing. He needed more time because he's not been able to remove the drugs. And that is kind of a key admission when you have your defendant saying, well, I need some time to unload the drugs. So one of the problems for Espinola was that he didn't have a way to sell the drugs, so Garcia arranged for him to buy a car without a down payment. As it turned out, the customer that Espinola sold his drugs to in the first instance was a law enforcement officer who arrested him. And then Espinola agreed to cooperate and made recorded phone calls. One of those calls was to Garcia, who at that point believed law enforcement was merely trailing Espinola, And he told Navarro that it was too hot to go back into the garage and get the bus out. So when Navarro testified, they asked him, "Did you discuss with Garcia? What did you discuss?" And he said, "Well, he was not in agreement that I take the car out of there." "Okay, so did you tell the defendant you needed to go in and get the car?" He said, "Yes." "Do you remember what he said?" He said, "Yeah." "What did he say?" He said, "Well, the drugs had been lost and that he did not know what was happening, that it was not a good thing for me to go back into that garage." On Sunday evening, law enforcement got a warrant, seized the drugs, and then they arrested Garcia and charged him with methamphetamine and conspiracy with intent to distribute. So the next issue that came up was the juror notes, and this is really one for the books. The district court began with a lengthy set of instructions, one of which said, "Don't discuss the case until the case is submitted. No preliminary discussions about what's going on in the case." And of course, in any trial, the jury is sent back and forth from the courtroom to the jury room 4 or 5 times when there are issues that have to be talked about out of their presence. Well, over the course of the 3.5-day trial, the court received 4 notes from jurors. The first note was from Mrs. Mantis, an alternate juror, who said, "Can we hear Garcia speak before watching videos to know what he sounds like?" To the defendant's lawyer, "How would you know about his mannerism if he doesn't talk, at least to us?" So the court solicited parties for suggestions on how to respond to that note, and everybody agreed that really they should just say, "We can't comment on the evidence," and that's what the court did. "The court has received your note but cannot comment or respond to your questions. The jury's verdict may be based only on the evidence introduced at trial and the instructions the court provides." Later that day, Mantis submitted her second note. She asked if a witness had forged his signature on one of the exhibits the government has entered. Obviously, the court commented to the parties outside the presence of the jury, "Mantis didn't get the message." Well, no kidding. The parties agreed that he would just repeat the same advisory. Later that same day, Ms. Barter, a different juror, submitted a note. Her note concerned the fact Garcia used a pseudonym, Palavas, but there was another person involved in the operation with a similar name, Polo. Barter worried there might be confusion. Her note said, "This is a question in regards to witnesses yesterday. The jury got a quick explanation that Polo, another individual involved in the crime, has the same name as the defendant, Luis Garcia. This occurred when the evidence of the photograph of Polo was projected toward the jury, and the witness on the stand answered that Polo was Luis Garcia. I would want to make sure that everyone is aware that that is irrelevant towards the evidence with the defendant's name listed on paper. Is there a way that could be clarified?" So at this point, the district judge was just exasperated, and he told the parties, "I am more concerned about the evolving pattern here. I've never received a note from a juror in any trial I participated in directly or as a judge where a juror was asking or making substantive commentary on the evidence entered. So I don't know why we're having this phenomenon. But every response we've given has only been calculated to stop this, but that's apparently, even the admonition this morning was not enough." Garcia worried that the use of the word "we" indicated that the jurors had been discussing the case. The government agreed that this was a concern. So the court repeated to the entire jury that both admonitions, the court cannot comment on the evidence, and that jurors were forbidden from deliberating until the close of evidence. But later that day, Mantis, the alternate juror and the author of the first 2 notes, submitted her third. This time she said that she'd seen a witness interacting with Garcia, and at this point Garcia sought to remove Mantis from the jury. The government did not object, and the court granted the motion because it said she clearly doesn't get it. After closing arguments, the jury began deliberations. About 50 minutes later, they asked for some technological help. Nearly 3 hours after deliberations began, the jury sent a note saying they'd reached a verdict, and they found Garcia guilty on both counts. So he challenged his conviction on the basis of insufficient evidence, that he knew he was transferring drugs, but the testimony of Navarro pretty much undid him on that. Turning to the second issue on appeal is that the district court abused its discretion in denying his motion for a new trial based on premature jury deliberations. Garcia points to 3 points of the trial where he believes they were deliberating prematurely. 4 total notes from the jury asking district judge to comment on the evidence, even though after every note the judge said he couldn't do that. The use of the word we in the third note, suggesting the jury had discussed the evidence and was confused about a part of it. And the government and the judge's concession that this repeated, unprecedented inability to understand instructions may suggest the jurors were deliberating. So, although we, like the district court, agree that something exceedingly unusual happened during the trial, there is not enough evidence to rebut the presumption under our court's demanding standard. A defendant can overcome the presumption by showing there is an overwhelming probability the jury did not or could not follow an instruction. Garcia is correct that Barter's use of the word we could suggest the jury had discussed the case, but there's an alternate explanation. Barter was confused and merely expressed worry that her fellow jurors might be confused too. In sum, we presume the jury followed the instructions not to deliberate prematurely because the juror notes, while troubling, are not overwhelming evidence that could overcome the presumption that the jury followed their instructions. Accordingly, we cannot say the district court abused its discretion in concluding that the jury did not engage in jury misconduct. Now, I'm bothered by this case for one very simple reason. It took them 3 days to try this case. 3 days. If the case was simple enough that it could be tried in 3 days, it could have been retried in 3 days. And if you balance the defendant's right to a fair trial against the time and expense of repeating that trial, it seems pretty obvious to me that the right calculus is to reverse this verdict and send it back to the trial court for a new trial, because the evidence is that the jurors did not follow instructions. Now, countervailing that is a long-standing policy that we respect jury verdicts, and we respect them even when a juror comes out and says things afterwards that, even though he said he wasn't biased, he was biased from the very beginning, as happened in the trial of the George Floyd police officers. It happens, and it shouldn't happen, but it does. And the question then becomes, at what point do you get a new trial? And I think in this case, the other thing that probably resulted in him not getting a new trial is the fact that the evidence really was fairly overwhelming in terms of his guilt and in terms of his knowledge. It's thus pretty unlikely that even if you had a new trial, that the result would be different. So I can understand why the Seventh Circuit reached the decision that it did, but I think you have to be really, really careful about sending a message to jurors that it's okay to ignore instructions. I think you have to be really careful about setting a precedent that says it's okay not to follow the jury instructions, because that is one of those things will eventually lead to essentially juror nullification. So that's what I have for you today. It's a little bit shorter of a case, and I received some criticism that some of my videos are running a little bit too long. Sorry about that. So trying not to go into quite as much depth in some of these issues, but hopefully you found this interesting. Jury service is one of those things that could happen to all of us, and if you get the opportunity, you should certainly do your civic duty. And it's good to be informed about what your responsibilities are. If you have any questions, leave them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. And perhaps most importantly, do something nice for somebody today. I'm going to take my wife to dinner tonight. She loves to go to the Mexican restaurant on Tuesdays for Taco Tuesday. And so I'm going to tip the waitress very well tonight, even if I get bad service, because sometimes you should just do nice things. Have a terrific day, and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.